Okay, time now is 1:05. Ekason, we are, what doing a join wani webinar being presented by Legal Immigration Lawyers in collaboration with DAM TV. Now, like I said, what we are delighted you could join us. You've put aside everything you've been doing to join this webinar. So what is the webinar? It's Understanding Indefinite Leave to Remain, ILR. Right now, there's been a lot of things going on around. How long will it take me to get ILR? My name is Olaide Osazua, and I work for Legal Immigration Lawyers. Few things, please keep your device at a setting not to disturb others, because when you're me, not one be. It's been recorded. We're in a webinar mode, which means it's being recorded and then it will be posted on our YouTube channel for people who have missed it to watch it again if they want to. Now, most people will be saying, I have this question, I want to clarify this. Type Q&A. Otherwise, at the end of the webinar, you will have a chance to ask any question at the end of the webinar. So what are we going to learn in this webinar today? What is in stock? What are we going to learn? The first thing is kini ILR go, indefinitely talk on kini, what is it? Go. How long ló máa take mi láti gba ILR at the moment, Now, kini ìjọba gan sọ, because you go on social media, you go on Facebook, TikTok, Instagram, there is a lot of information about it. But what is the government actually saying about this indefinite leave to remain? So let's go into it. Now, the first thing is, what is ILR? Yeah, indefinite leave to remain. Indefinite leave remain. So simply, it means you can stay in the UK for as long as you want. Usually they about wasi lui, but you work for students, one for any visa or do kan abodun meji, post study one for any visa or do kan abodun meji. But for indefinite leave to remain, kò sígbà tí visa might expire. Àfi tí home office bá gbà, àbí tí wọ́n fúnra rẹ̀ bá ṣe nǹkan tán fi gbà, bóyá for instance, bóyá o kúrò nílùú, ó pẹ́ gan, ó padà. So it's not citizenship, but it gives, having indefinite leave to remain gives you the right to stay in the country for as long as you want. You can work with no time limit. You can study in the UK. Pẹ̀lú indefinite leave to remain, kò sí pé visa mi fẹ́ expire o, mo need àti ká application jọ o. No. You need àti ṣe visa kankan mọ́. O lè gba benefits. You can go and claim benefits. And tó bá dẹ̀ fẹ́ náà o, generally, after 12 months, generally, of course, oríṣiríṣi òfin ló wà, but generally, after 12 months of being indefinite leave to remain, tó bá fẹ́, you can say, okay, I want to become a British citizen. Ìwọ tó bá wà lórí skilled worker visa, tó bá ní indefinite leave to remain, you can change your employer. Kò sí pé employer ló gbé mi wọ̀lú, so mi lè change iṣẹ́ mi easily. No, with indefinite leave to remain, you can change your employer. So you could tell immediately that there is a lot of benefits that comes from having indefinite leave to remain. Now, báwo lèèyàn ṣe lè gba indefinite yìí báyìí ní as of today o? Báwo lèèyàn ṣe lè gba indefinite leave to remain? Oríṣiríṣi ọ̀nà ló wà. Our lawyers máa ń pè àwọn kan ní route that leads to settlement, or some visa that leads to settlement. A dẹ̀ tún máa ń sọ pé àwọn kan wà tí ò lead sí settlement. So generally, ṣe bá àwọn route tí ò lead sí settlement yẹn, as of today, tó bá ti wà nílùú for 10 years, tó níwèé, tó ní pálí ẹ̀, even though you are on a route that doesn't lead to settlement, but if you've been in the country for 10 years lawfully, then you can apply for indefinite leave to remain. Mo ṣe àpẹẹrẹ or example sójú screen pé ká imagine Mr. A ó wọ̀lú ní 2017 on a student visa. Ó parí degree ẹ̀, ó parí PhD ẹ̀, ó dẹ̀ switch sí graduate visa, ó dẹ̀ wá gba skilled worker visa. Now, torí pé ó ti ń gbèlú láti 2017 tó dẹ̀ níwèé, by next year 2026 làwa wà by next year ó lè apply for indefinite leave to remain here even though ó ṣẹ̀ṣẹ̀ bẹ̀rẹ̀ skilled worker visa ni but torí pé ó ti wà nílùú for 10 years lawfully even though it might be on a route that doesn't lead to settlement, he can apply for his indefinite leave to remain. Now, some temporary visas don't count towards the 10 years. An example is visiting visa. Now, for the route that leads to settlement, pé tó bá ti wà lórí ẹ̀ o, ọjọ́ tó bá ti bẹ̀rẹ̀ lórí ẹ̀ ló ti bẹ̀rẹ̀ sí ń ka settlement ẹ̀, it is usually 5 years at the moment. Mo dẹ̀ tẹ́ bá wo screen mi ẹ̀ rí. For instance, skilled worker, tó bá ti wà lórí skilled worker for 5 years, wàá gba indefinite ẹ̀. Tó bá wà lórí global talent, for instance, depending on the type of global talent tó wà, between 3 to 5 years, wàá gba global talent ẹ̀. Àwọn asylum náà, refugee, usually 5 years, wàá gba indefinite ẹ̀. Armed forces, bóyá o wà lára àwọn tó ń bá wọn ja ogun, it depends, usually 4 years, but if you are discharged because of medical reasons, it could be lesser. But tẹ́ bá wojú board ẹ rí pé most categories are 5 years, so that's why we said it takes generally 5 years. But for you to get it, you must be on the 5 years route, or you must be on a route that leads to settlement. If you are not on a route that leads to settlement, then you are looking at 10 years. To help a student, to extend, to wish as long as you've been in the country for 10 years lawfully, then you could apply for your indefinite leave to remain. But there are still some routes as well. To jẹ́ pé ó vary between 5 to 10 years. For example, Soju board. For instance, ọmọ tó wọ̀lú, ó ti wá dàgbà, ó ti pé 18, but ìgbà tó wọ̀lú ọmọ kékeré ni. We usually call that category private life young adults. So if they come to the UK, they are under 25 years as of today, but they've arrived in the UK before they are 18 and they've lived in the UK for half of their life, then they can be on the route to settlement within 5 years. Within 5 years. So wọ́n wà under 25, wọ́n ti gbélùú for more than half of their life, then they can apply for settlement under private life as a young adult and get their indefinite leave to remain within 5 years. But fún àwọn èèyàn míì, àwọn àgbàlagbà míì tó jẹ́ pé wọn ò níwèé, wọ́n kàn wà nílùú, bóyá wọ́n fi visiting wọlé o, wọn ò padà, àbí bóyá wọn ò tiẹ̀ fi visiting kankan wọlé, ojú boat náà gbá wọ̀lú, wọ́n ṣàkọ̀ wà nílùú, wọn ò níwèé, wọn ò ní kankan. Àwọn wọ̀nyẹn, they are looking at, wọ́n kọ́kọ́ lo 20 years nílùú náà. Tó bá ti wá fún wọn ní 20 years yẹn, wọ́n á máa renew ẹ̀ every 2.5 years for another 10 years. So they are looking at around 30 years kan tó lè gba indefinite wọn. So it's 20 years of living in the country láì níwèé. Then tó bá ti wá gbàwé yẹn, wọ́n máa fún wọn ní 2.5 years lẹ́ẹ̀mẹ́rin. So ó jẹ́ 30 years. Total jẹ́ 30 years. Then after that, wọ́n ṣẹ̀ wá máa gbé indefinite leave wọn. But again, Home Office not recognize pé there are some situations tó jẹ́ pé for one reason or the other, it's just not possible for you to go back to your country, So if you are an adult, you don't have any paper in the country, and you've lived there for less than 20 years. When I say paper, I mean visa. You've lived there for less than 20 years, but there are serious reasons why you cannot go back to your country. We use the word insurmountable obstacles. Then you can present your application to the Home Office and they will look at it. And somebody they accept reason, then again, you will be on the 10 years route to settlement. Now, sọ pé àwọn kankan wà tó jẹ́ 5 or 10 years route. Àti sọ private life being ọmọ tó wà under 25 years, for instance, that one can be on 5 years route to settlement, or àgbàlagbà tó jẹ́ pé ó ti wà nílùú tí ò ní time, that one can also be on 10 years route to settlement. Now, we also have the family life route, which could be partner or parent of someone settled or a British citizen. So what do I mean by that? So bóyá mo bí ọmọ tó jẹ́ British, àbí ọkọ mi jẹ́ British, I can be under the 5 years route to settlement or 10 years route to settlement. Now, báwo ló ṣe máa ń mọ̀ bóyá 5 years route ni mo wà àbí 10 years route ni mo wà? Usually, I will be on the 5 years route tí n bá satisfy àwọn requirement kọ̀ọ̀kan. Generally, bóyá mo ní English test, mo ti mo lówó iye owó tí mò ń gbà, iye owó tí government ní pé a gbọ́dọ̀ máa gbà to be on the 5 years route, you know, mi ṣe overstayer, mo níwèé mi, then most of the time those people are on the 5 years route. But where you cannot meet all of the requirements of the rules, but perhaps there are exceptional circumstances that being kokonwa, then you will be placed on the 10 years route to settlement under the family life route. You know, so being on the 10 years route does not mean you cannot switch to the 5 years route if you meet the requirements. Now, people on the 5 years route usually want legal benefits, you know, or housing support. One restrict one because our requirement 5 years route ni pé not necessarily share, but o ti justify, o ti show one pé o lówó kan. So generally, one lè gba benefits. But see, circumstances won't bad change, you know, one leave 1 second, and things could change. Then one while they make separate application for the Home Office to allow them to get benefits. The other people as well, tó jẹ́ pé wọ́n lè qualify for indefinite leave to remain straight away. You know, ṣe mọ̀ pé a ti ń sọ̀rọ̀ pé ó ti gbọ́dọ̀ gbélú for 5 years, 10 years. In fact, a tún sọ pé àwọn kan gan 30 years. Àwọn tí ò ní ìwé rárá, it could be up to 30 years. But àwọn kan wà tó jẹ́ pé tí situation kan bá ti occur, they don't even need to show anything. They can then apply for the indefinite leave to remain. The first category is bereaved partner. You know, you know, if someone comes here, they married a British citizen, and unfortunately, the British citizen died. From the point that that person died, the migrants in your visa apply for indefinite leave to remain straight away. They are called bereaved partner. Then victim of domestic abuse. Again, example tí mo give yẹn, ó fẹ́ ọkọ ẹ as a British citizen or as someone to need indefinite leave to remain, or ìyàwó ẹ, you know, men do suffer from domestic abuse as well. And unfortunately, you then happen to be a victim of domestic abuse, then it may be possible for you to apply for indefinite leave straight away, regardless of how long you've lived in the UK. What about àwọn ọmọ kéékèèké? You know, àwọn ọmọ náà wọ́n tẹ̀lé ìyá wọn wá, àbí wọ́n lè bí wọn síbí, ìgbà wo náà lọ́n lè qualify for indefinite leave to remain. Ọmọ tó bá bí sílùú yìí, tó bá ti gbélùú yìí for 7 years, could potentially apply for indefinite leave to remain. Wọ́n bí ọmọ sílùú yìí, ó ti gbélùú yìí for 7 years, that child could potentially apply for indefinite leave to remain. But ọmọ tó bá bí sílùú yìí, bóyá ó tẹ̀lé ìyá ẹ̀ wá, àbó tẹ̀lé bàbá ẹ̀ wá, àbó tẹ̀lé àwọn méjèèjì wá, ọmọ yẹn lè qualify náà fún indefinite leave to remain nígbà táwọn parents ẹ̀ bá ti ń apply. And generally, táwọn ọmọ náà bá ti lò 5 years, generally on the private life route, then they can qualify for indefinite leave to remain. Now, so far, a ti sọ̀rọ̀ nípa nǹkan tó wà báyìí, you know, how do you qualify for indefinite leave to remain? But I'm sure a lot of you have been hearing they want to change it to 10 years, they want to change it to 15 years. So what is the government proposing? Can the government go so let's move into what the government is proposing. What change? Ká tó sọ̀rọ̀ nípa nǹkan tó ń fẹ́ ṣe, most highlight some key points. The first thing tó ń sọ ni pé indefinite will no longer be granted automatically after a fixed period. Shemo. Instead, migrants will need to earn it by demonstrating sustained good conduct, contribution, and integration. Yorùbá mi ò straight. I can't. You have to work for it. You know, pé kíkan ṣe pé mo ti wà lórí skilled worker for 5 years o. Ẹ wá fún mi ní indefinite leave to remain because mo ti wà. Eléyìí báyìí wọ́n wá ń sọ pé bí ẹni pé a gbọ́dọ̀ ṣiṣẹ́ fún indefinite yẹn ni. And nǹkan tó ń wò ká fi ṣiṣẹ́ fún is our good conduct, our contribution to the UK, and how we've integrated to the UK. Àwọn èèyàn, nǹkan táwọn èèyàn ń béèrè ni pé, okay, kí ni pé ká máa ṣiṣẹ́ fún the end settlement ọkàn ń pariwo ẹ̀, ṣó ti dòfin? Ṣó ti dòfin? The simple answer to that is no, kò tí ì dòfin. Consultation ni. And any consultation, it means the government are asking for our views. You know, they want to know, you know, but this is the time that they are asking for our views. question táwọn èèyàn míì tún máa ń béèrè ni pé ìgbà wo gangan ló máa dòfin? Again, answer yẹn ni pé mi ì mọ̀. But wọ́n consultation pé wọ́n ń fẹ́ view wa, wọ́n fẹ́ ká dá sí, ó ṣì wà on. Wọ́n dẹ̀ ló máa wà on until 12th of February 2026, which is next month. But wọ́n ṣe nǹkan kan fún House of Commons o tó indicate pé wọ́n plan, not that they will, wọ́n plan àti bẹ̀rẹ̀ pé kán sọ̀dà òfin around April this year. Again, just to summarize, it is not the law yet. They are seeking for our views. And this is the time, gbogbo pa ń pariwo lórí social media, à ń ṣe gbogbo ẹ̀wọ̀n yẹn. Responding to the consultation has more force than just saying this is what the government wants to do. Now they are seeking for our views as to what we feel about it and how they should do it. Now, kí ló fẹ́ ṣe òun gangan? Kí ló ń béèrè view wa fún? Wọ́n sọ pé kéèyàn tó gba indefinite leave, ó máa need 10 years. 10 years yẹn dẹ̀ lè lọ sókè, ó dẹ̀ lè lọ sísàlẹ̀ based on nǹkan tẹ́ni yẹn ṣe. So wọ́n ya table mẹ́ta. So lórí table mẹ́ta yẹn, lẹ́ni yẹn 10 years ní by default. But based on nǹkan tó bá wá ṣe by each table, ló wá máa mean pé ó lè lọ sókè o, ó dẹ̀ lè lọ sísàlẹ̀. Now, table 1, ṣẹ́rí yẹn báyìí, wọ́n ní wọn ò gbà view wa lórí yẹn, pé wọ́n fẹ́ go ahead pẹ̀lú ìyẹn. So they are not really seeking our views on that table 1. So there are 3 tables. Table 1 is a mandatory one. The only thing tó ń béèrè lórí table 1, wọ́n ń béèrè nǹkan kan lórí table 1, màá fi table yẹn hàn wá in the next slide. Wọ́n ń béèrè nǹkan kékeré lórí table 1, but generally most of nǹkan tó wà lórí table 1, wọ́n ní wọ́n fẹ́ ṣe regardless of nǹkan tá a bá sọ. But table 2 and table 3, ṣẹ́rí table 2, ó lè reduce 10 years wa, 10 years yẹn. And table 3, ó lè add mọ́. So tí n bá simplify it, table 1, most of the things on table 1 are compulsory. So you can't get your indefinite leave to remain if you have not met most of the conditions of table 1. And the government have said they are not really seeking our views on table 1, except for some few things, which I will go to shortly. Table 2 is what could reduce that 10 years, and table 3 is what could increase that 10 years. Now, so let's look at the tables. Now, so the table 1 is suitability, integration, and contribution. So, ṣẹ́rí table, the government ò fẹ́ view wa except the length of time of the income. So, tẹ́ bá wo table 1 báyìí, wọ́n ní a suitability generally, ní criminal conviction, wà dédé, ní issue ọlọ́pàá, ní things like that. That's the issue of suitability, purọ́ kó tó wọ̀lú, all those things. Tọ́ máa mọ̀ pé purọ́ àbò ṣègbéyàwó kan tí ò lórí, tí ò lórí, tán mọ̀, this suitability could affect you. Then ṣó jẹ gbèsè, àwọn èèyàn míì wọ́n lè jẹ gbèsè pẹ̀lú NHS or other government bodies and things like that. That is suitability. That could affect your indefinite leave to remain from what they are saying. The second one is integration. Now, they are asking that people should be able to pass English test up to B2 level. Ṣẹ́rí méjì yẹn, suitability and integration, wọ́n làwọn fẹ́ ṣe yẹn o, wọn ò fẹ́ gbọ́ nǹkan tá a fẹ́ sọ. So, integration, passing English test, B2 test, and live in the UK test. They want us, they are not seeking our views on that. But as to contribution, so wọ́n sọ pé ó yẹ kéèyàn lè máa gbà above 12,570 for a minimum of 3 to 5 years before they qualify for their indefinite leave to remain or an alternative amount of income. So ṣé rí oyè level oyè tá a fẹ́ gbà àti period yẹn, wọ́n ń béèrè view wa on that. So the contribution aspect in this table is subject to consultation, which means you can respond as to whether it should be 3 years, it should be 5 years. The government are asking for your view. That's table 1. Now, table 2, kí ni nǹkan tá a lè ṣe tó lè reduce 10 years yẹn from maybe 7 years to 9 years or whatever. That is table 2. For this table, lè mú méjì o, so èèyàn kan ló máa mú according to them. So lè sọ pé bóyá èèyàn kan wà, tẹ́ bá wo table yẹn báyìí, so wọ́n ní èèyàn tó bá pass English test up to C1 level, that's -1, and èèyàn lè qualify for indefinite leave within 9 years. Or èèyàn tó jẹ́ pé bóyá global talent ló wà, for instance, wọ́n ní global talent lè reduce from 10 only your 7 years, so only reduce it from 10 to 3 years. Lè sọ pé torí pé mo ti ní English at C1, that's -1. Mo tún wà lórí global talent, that's -7. Kò wá sọ pé 2 years ló kù. No, you can only pick one on the table. So ilé tó bá favour ẹ ni wàá mú. Ṣé rí gbogbo table yìí is subject to consultation. Government ń béèrè lọ́wọ́ yín pé ṣé kán ṣe àbí kán má ṣe. So ìwọ tó bá ní English test up to C1, that is -1 from the indefinite leave to remain. Ìwọ tí income ẹ bá jẹ́ over 125,140, that could be -7. So you could possibly qualify for indefinite leave within 3 years. Àwọn tó wà ní specific public services, so like NHS workers, a máa lọ sáwọn care in a minute, but generally if you are bóyá ò ń ṣiṣẹ́ pẹ̀lú paramedics, pẹ̀lú àwọn ambulance, again, wọ́n reduce it for 5 years. A reduction of 5 years is possible, meaning you will qualify for your indefinite leave to remain for within 5 years. Now, government sọ pé kò ní affect spouse of British citizen. And I take exception to that because what they've said in the consultation is British citizens who have met the core requirements. Now, ṣé wá rántí lẹ́ẹ̀kan mo sọ pé 5 years route wà fún family visa, 10 years route wà. Ìwọ tó bá wà lórí 5 years route ló meet the core requirement. So again, tó bá wà lórí, tó bá jẹ́ partner of a British citizen of parent of a child, -5 years. But àwọn tó wà lórí 10 years ńkọ́, question mark wà lórí wọn. So this is just a summary of table 2. Now table 3 ló máa add mọ́ 10 years yẹn. Ìwọ tó bá ti gba benefit for less than 12 months, ó lè add 5 years mọ́. Indefinite yẹn add move from 10 years to an additional of 5 years, á jẹ́ 15 years. Ìwọ tó bá gbà for more than 12 months, an addition of 10 years. Ìwọ tó bá wọ̀lú láì ní ìwé, bóyá o gba boat or illegally wọlé, that is an addition of 20 years. So that is 20 plus 10, that's 30 years. Ìwọ tó be visiting wọlé, addition of 20 years. Ìwọ tó overstay again for more than 6 months, an addition of 20 years. Again, everything on this table is subject to consultation. Mo fi table yìí síbẹ̀ in the sense that ó dàbí pé wọ́n fẹ́ scrap the lawful the 10 years lawful residence, because at the moment, well, from what they are proposing, not at the moment, from what they are proposing, they are saying most people will, whether regardless of your immigration status, you will only, the 10 years will be the baseline. And they've said this, in order to meet the qualifying period requirement, the applicant will need to have spent the required period of time in the UK in a route or route that leads to settlement. Tẹ́ bá rántí pé ìgbà tá a bẹ̀rẹ̀, mo sọ pé route to settlement wà, route to non-settlement wà. So it means the 10 years would not start until you have been able to switch to a route that leads to settlement. So ó dàbí pé government first scrap 10 years sí lawful residence tó bá wà ní route that leads to settlement. Linked to this is overstayers. You know, ṣé mo sọ pé tó bá jẹ́ overstayer tó wá lùyìí, ó gbé lùyìí for 20 years, then you can then switch to private life, and after 10 years on the private life, then you get your indefinite leave to remain. If that is the case, overstayer will first of all struggle to get a visa, and then tẹ́ bá wo table yẹn, does that mean pé lẹ́yìn ìgbà tó bá gba private life rẹ̀ yẹn tán, wọ́n ṣẹ̀ṣẹ̀ tún wá add another 20 years mọ́, or 5, 10, 15 or 20 years, and this means overstayer might need 30 to 50 years before qualifying for the indefinite leave to remain. That is yet to be seen. Now, additional point láti note ni pé ṣé mọ̀ pé báyìí bóyá ọkọ àti ìyàwó wọ̀lú or unskilled worker, after 5 years wọ́n ti gbélùú, wọ́n qualify for indefinite leave to remain. But government sọ pé each person will be decided by their own situation. This means tí dependent bá ní shorter period though, ó máa need àti dúró that the main applicant, because the dependent cannot get settlement until the main applicant has got it. But where the main applicant has qualified for it, but the dependent is not, the dependent, maybe bóyá dependent wọlé pẹ̀lú visiting, so ká imagine ọkọ àti ìyàwó ó wọlé pẹ̀lú skilled worker, ìyàwó ní skilled worker, after 5 years ìyàwó qualify, ọkọ náà at the current rules lè qualify after 5 years. But tó yẹ pé ọkọ wọlé pẹ̀lú visitor, for instance, ẹ má gbàgbé wọ́n lè add 20 years more because he came in on visiting visa. So we now can have a situation where the main applicant qualifies within 5 or 10 years or 3 years, however, if there is any deduction they can use, but the 10 years baseline. But the dependent may not qualify until much later, or may not even qualify because they've done some things wrong before. So, however, it doesn't work the other way around. So if the dependent qualify, but the applicant doesn't qualify, they wouldn't grant it to the dependent. Now, again, government ń bèrè nípa tàwọn ọmọ kékèké, because, for instance, ọmọ kékeré wọn fẹ́ put wọn at disadvantage. Ọmọ kékeré, for instance, ó lè má ti bẹ̀rẹ̀ iṣẹ́, so kò lè ní benefit contributions sí fóun tí ń ṣiṣẹ́ yẹn. So they are seeking consultation on how to go about it. Then what happens? Ṣé àwọn pé mo ti sọ pé every individual ló fẹ́ máa assess dependent. Then what happens? Tọ́mọ bá tán 18, Home Office ń wò pé kán ṣì maintain bó ṣe ń ṣe báyìí pé táwọn ọmọ bá ti ń gba táwọn parents bá ti ń gba dependent, kán jẹ́ káwọn ọmọ gba táwọn parents bá ti ń gba indefinite leave, kán jẹ́ káwọn ọmọ náà gba indefinite leave wọn. But again, there may be some time náà tó jẹ́ pé ṣé pé 10 years pẹ́, 10 years wọ́n sọ pé wọ́n tún fẹ́ máa hà di 20 years láti oríṣiríṣi mọ́. Kí ló wá máa ṣẹlẹ̀ sáwọn ọmọ dependent yẹn? Home Office ń wò pé later on náà pé káwọn ọmọ yẹn náà qualify in their own right. But wọ́n tún wá ń wò náà pé kán tún qualify pẹ̀lú àwọn parents wọn. But wọ́n ń wò pé there should be a cut-off age pẹ̀lú tán lè qualify pẹ̀lú parents wọn, pé there should be some time náà táyà expect pé kọ́mọ yẹn náà ti lọ máa ṣe nǹkan kan fún ara ẹ̀. Okay? But children, they are seeking consultation. So ẹ jẹ́ ká wo oríṣiríṣi pẹ̀lú example. Ẹ já wo Mrs. Didi, ó wọlé ní 2021 as a skilled worker. Pẹ̀lú nǹkan tó ń ṣẹlẹ̀ báyìí, 2021 we had 5 years to it. By 2026, Mrs. Didi á gba indefinite leave to remain. But kí ni wọ́n fẹ́ ṣe? Wọ́n fẹ́ change ẹ̀ sí 10 years, which means kí Mrs. Didi tó lè qualify fún indefinite leave to remain, ó máa wo 2031. But tó bá yẹ pé ó ń gba 50,270, for 3 years, that 10 years can be reduced to 5 years. Tó bá ń gba 125,140 for 3 years, that 10 years can be reduced to 3 years because one reduced the 7 years. That's one example. Àtúwò kéèsì Mr. Baba, ó wà married to a UK citizen. Ó meet gbogbo requirement 5 years route. 5 years. Kò sí nǹkan tó ń change lọ́dọ̀ ẹ̀ because ó meet requirement. But tó bá yẹ pé kò meet nǹkan kan o, bóyá kò meet financial test, tó wà lórí 10 years route, ó lè lọ sí 10 years, wà lórí 10 years route as of nǹkan tá a wà báyìí. But bóyá tó financial lè mood, bóyá kò lówó, ó lọ claim benefit. Ẹ má gbàgbé, table 3, wọ́n lè add the total of 15 to 20 years torí pé ó claim benefit. Àtúwò case overstayer, Miss Katz, ó jẹ́ overstayer. Ní nǹkan tá a mọ̀ báyìí, tó bá ti gbélú for 20 years, ó lè apply fún 2.5 years visa. A ṣe 2.5 years visa yẹn fún ọdún mẹ́rin, á dẹ̀ gba indefinite yẹn. But pẹ̀lú nǹkan tí wọ́n fẹ́ gbé síta, tán sọ pé àwọn fẹ́ gbé síta, àti ẹ̀mọ̀ bóyá Miss Katz kọ̀ọ̀kan máa ní visa ẹ̀, but káàtì ẹ̀ imagine kó máa ní visa ẹ̀. That means pé ó máa lo 10 years, á kọ́kọ́ lo 20 years as overstaying tí ò ní ìwé kankan. Á ṣẹ̀ wá lo 10 years lórí 2.5 years, 2.5 years. Then the fact pé ó ti overstay before, wọ́n wá lè mí pé wọ́n tún lè add 20 years mọ́ kó tó lè gba indefinite leave. So wọ́n wo bí 50 years kó tó lè gba indefinite leave to remain. Àní rí nǹkan tí ò dá. Then mo tún ṣe example Mrs. Dean tó wọ̀lú on a visiting visa. Ó bímọ, ó dẹ̀ gbàwé torí ọmọ ẹ̀ on the parent route. Torí pé right now usually wọ́n lè put it on 10 years route, But torí pé ó wọlé pẹ̀lú visiting, she would not meet the requirement for the 5 years route as it is now, and she could be placed on the 10 years route. But ní nǹkan tó ń propose o, torí pé ó wọlé pẹ̀lú visiting, ó lè ní an additional 20 years, which means 10 years the baseline plus 20 years for coming in as a visiting, making a total of 30 years before obtaining an indefinite leave to remain. Global Talent 1. Global Talent, usually at the moment, within 3 to 5 years, one qualify for indefinite leave to remain. But nǹkan tí government propose ni pé kán ṣe reduction 7 years. So which means Mrs. E in this example on the screen could potentially qualify for indefinite leave within 3 years under the new proposal by the government. Mo ṣe example àwọn specific public service. Now this is where I talk about the carers. Yeah. Let's take the case of Mr. Freddy, working for the NHS as a doctor. At the moment, he will qualify for indefinite leave to remain within 5 years. Now, from what the government is proposing, for instance, if he has proficiency in English at C1, then he can get it reduced. From what the government is claiming, he can get, because he has English proficiency at C1, to pass English test at C1, then he can get the 10 years reduced to 9 years. Then torí pé ó jẹ́ doctor tó ń ṣiṣẹ́ pẹ̀lú NHS, ó lè tún gba 5 years, but kò lè mú méjì, ẹyọ kan ló lè mú, so ó lè get 10 years and reduce to 5 years torí pé ó jẹ́ doctor tó ń ṣiṣẹ́ pẹ̀lú public service, but ẹyọ kan ló lè mú, kò lè mú English kó tún mú ti doctor. So usually, naturally náà, á mú ti doctor pé òun ṣiṣẹ́ pẹ̀lú public service, so 5 years, ó lè qualify pẹ̀lú indefinite year. Now ẹ jẹ́ wá wo ìyàwó ẹ̀ tó jẹ́ pé carer ni. Torí pé ìyàwó ẹ̀ jẹ́ carer, now nǹkan tí government fẹ́ ṣe fáwọn carers, not just carers, they said anyone that is below RQF6, which carers falls into that category. They said people like that may have to wait for 15 years before qualifying for their indefinite leave to remain. Again, this is the time to respond to the government consultation. Is what the government are proposing. They are asking for your views about it, and before they finalize everything. So let's take the case of Mr. Freddy. I'm sorry, ìyàwó ẹ̀ pé ká ní pé ìyàwó ẹ̀ ló ń ṣe RQF. So Mr. Freddy lè qualify for indefinite leave to remain within 5 years. But ìyàwó ẹ̀ tó bá jẹ́ pé kò meet table, ìyàwó ẹ̀ lè máa wo 15 years kó tó lè wo indefinite leave to remain. So even though Mr. Freddy ti lè qualify o, ìyàwó lè má ti qualify. Ẹ má gbàgbé pé wọ́n láwọn fẹ́ wo dependent separately. Now, tá bá tún wá reverse situation yẹn, ká ní Mrs. Freddy ló ní skilled worker. Yeah, òun ló ní skilled worker as a care worker. Ọkọ Mr. Freddy kàn ṣiṣẹ́ as a doctor ni. So even though Mr. Freddy lè ti qualify for indefinite leave to remain, wọn ò ní fún torí dependent ni. Ìyàwó ẹ̀ ò ní qualify until 15 years time torí care visa ló wà. So Mr. Freddy may need àti dúró 15 years torí pé ìyàwó ẹ̀ ò tí qualify. I know a lot of people are in the care sector and they are struggling. I have the utmost respect for people in the care sector for the work they are doing. If you are being affected by any of these, the recommendation is seek legal advice. We will be happy to assist you in legal immigration lawyers. That's what we do. Now, another example is for someone settled in the UK. Now, this example, I've put it there because they've clarified that it wouldn't affect spouse of British citizen. How about spouse of people on indefinite leave to remain? So I gave the example of Mr. Gogo. Mr. Gogo is here in the UK and Mrs. Gogo is here in the UK as his partner. So Mr. Gogo is the one with indefinite leave to remain. Mrs. Gogo is under the 5 years route to remain. Now, Mrs. Gogo came to the UK 15 years ago as a visitor and overstayers. With the new rules applied to Ms. Gogo, it could be, as the promise to keep the 5 years relates to partners of British citizens and not spouse of someone settled in the UK. So therefore, Mrs. Gogo could have an additional 20 years to the 10 years before qualifying for indefinite leave to remain, because she entered on visiting visa. We do get a lot of questions about benefits as well. What the government is also talking about benefits. They are saying, the government is also seeking whether settlement, because right now, tó bá ti gba indefinite leave to remain, or they claim benefits, generally. But they are saying settlement should come with a no recourse to public funds condition, meaning after getting settlement, migrants cannot claim certain benefits. If this happens, access to benefits or public funds in terms of immigration rules would only come with citizenship, not settlement. And this is going to be a big change to the current system where settlement gives full access to benefits. I know it's a lot to take in, but that is what they are proposing. One question people ask me is, can someone challenge it? Tell one the challenge, 50 years to get indefinite leave, and it's a lot. It is a long time. The simple answer to that is not at the moment. I consider to challenge at the moment because it is a finger. They are saying they want our views. So it's not the law yet. You call it challenging because they are still seeking, for our views. Okay? And I get people also saying, I came to the UK 2022, 2023, and when I was coming in, I'm coming in under the 5 years route. Surely, the proposed 10 years baseline should not apply to me as I'm already here in the UK. Sadly, it could apply. The government are asking whether it should apply or not. You know, they are asking whether ṣé kó apply sáwọn tó ti already wà níbí àbí kó má apply. Wọ́n ṣì ń béèrè ni. So we don't know whether it's going to apply or not. This is the time to respond to the government consultation. So you might be thinking, what can I do now? I haven't know this information. I haven't know what is coming. What can I do now? The first thing I tell people is, if you are due for your indefinite leave to remain, or you are due for your citizenship, go and make that application. Do not delay it anymore. And I would highly recommend, Masape, do the application with the advice of a legal, with the help of a lawyer. And that's what we do. Legal immigration lawyers can assist you in doing that. If you can pay for priority service, super priority service, and is available for your type of application, do it now. You know, again, I will recommend that you do it with assistance of a legal representative because you don't want any mistake, especially considering what the government are proposing. You don't want any mistake and the law is already in effect and rectify it becomes complicated. So get legal advice before you submit legal application is recommended, and don't delay your application. Indefinite leave to remain, you qualify for it. Apply now. Now, citizenship as well. They've also confirmed that more changes are coming for citizenship. In fact, it appears they are waiting to implement this one on indefinite leave to remain before implementing the one on citizenship. So again, if you're qualifying for citizenship, do not delay your application. And I've said this over and over, that is still a consultation. If there is any aspect of the consultation, respond to the consultation. Individuals, need that organization or anybody, you as an individual can participate. They've said they will make it anonymous so that one email to reply. But one can keep internet address, IP address, so that in your major reply, you know. And I would say people from abroad could reply because they said anyone could apply. So if you have people in Nigeria that is thinking of coming to the UK, this thing could affect them. Anyone they said could reply to it. You know what they've said is, and they said they will keep it anonymous. So only that for people will reply, but one of them keep IP address so that because in your if phone go reply they don't want that. So that's why they are keeping the IP address. Encourage others. I've mentioned it as well. I think people abroad is able to complete the consultation as well. And of course, if you need legal advice or you need clarification, don't forget we are here to assist you at Legal Immigration Lawyers. That is it. You talk, we listen, we act, and we are here to act for you. So I'm just going to give time for question. If there is anyone that have question, you may ask now. Preferably if you put it in the Q&A, I can pick it up from there. No one has put any question there. But otherwise, you can ask your question. Yeah, one at a time. One question for one person, just to give everyone the chance to ask question across.
Thank you so much. Yeah, thank you so much for today's seminar. I really appreciate you. And God is going to bless you. And for those people that attend today, we really appreciate you. This is DAM TV and family, and collaborate with the lawyer. We are a community which we are supporting all the Nigerian people. If you join the community, you can have a consulting. You can have a consulting free. And
sorry, I don't think I mentioned that. Sorry, Emma Binu.
Yes.
So legal immigration lawyers, we work regularly with DAM TV, and this webinar is delivered only for people at DAM TV. Yes, I did say it's going to be recorded, it's going to be posted on YouTube, but we are presenting it now only for the people in DAM TV. And once a month, every Tuesday, we do have free consultation. DAM TV organized that, and you can book to see one of our legal advisor at Legal Immigration Lawyers. Most of the, like it's been said, is Nigerian community and Modetiso Yoruba not throughout this webinar. I'm not, I mean, there's something fluent in Yoruba. I speak Yoruba, but I tend to dilute it. So we do, if your preference, if you want for us to speak to you in Yoruba during the consultation so that you can understand the advice. The whole lessons, one thing we do it at Legal Immigration Lawyers and at DAM TV, we haven't worked with DAM TV, is that we want the other party to understand what is going on. So it's not a question of Kpa Mama Soyibo, you will not understand. So if you want to have it in Yoruba, we will do that. And if you want it to be in English, we will do that so that you don't walk away not knowing what has been said. So we do that consultation regularly, and we do webinar like this regularly as well. Yeah, am I missing anything, DAM TV?
No, but let me have the last one. And this seminar, it will be coming up every three months, and we'll be posting the time. So if you join, you will have all the support of the community. Even if you come with the free consulting, then if there's any information, maybe you've decided to say, okay, I'm good to go with your job and I'm ready. Do you know that you will still get 10% of the money paying for the lawyer? So all those activities is meant for people that join the community. And there's a lot of activities going on. So feel free to join the community. This is DAM TV. We are all on social media. We have website as well. So thank you. Let me give a way for people to ask questions. So thank you, ma. We really appreciate you. Yeah.
So any question? Thank you very much. Any question before we finish?
Hello.
Yes.
Can you hear me? My name is Mabel.
Good afternoon. I can hear you.
The explanation, though I was not really disposed, but I had quite a lot, and it was really explanatory. Okay, like me now, I came in September as a student, and my family is in Nigeria. I have a husband and 3 children. I was thinking, how will my situation now be?
Under the new consultation.
Yes.
Right. So student is a route that doesn't lead to settlement at the moment. Normally, if you've been here as a student, for instance, if you happen to be here as a student for 10 years, as of today, then you can claim your indefinite leave to remain. But from what the government are proposing, it seems to be categories like students might need to switch. So it's like they are scrapping the 10 years lawful residence, and until you switch to maybe skilled worker or any other form that leads to settlement, you will not be counting towards your indefinite leave to remain.
Okay. Thank you.
Yeah, no problem. Any other question?
Is there any questions, or we should call it a day? Yeah, if there's no any questions.
Hello.
Okay.
Hello.
Yeah, thank you, ma. If you have a child, if you are on a skilled worker visa and you have a child, how
Can
long
we know
does
your
it?
name, please?
My name is Damilare
All
from
right.
London. Yes, sir.
Okay. Yeah.
Okay. Yeah, if you are on a skilled worker visa and you have a child, do both of you get the earlier at the same time? The child has his own years to get it.
Are you talking about what is happening now or what the government are proposing?
What the government are proposing.
Yeah, so if you have a dependent child on the skilled worker route, from what they are proposing, like I said, it's still a proposal. It's still, they're still seeking consultation. So they're asking for views on children, but they are thinking that maybe children should still qualify with their parents as it is now. But don't forget, we are talking of 10 years, 20 years, however long. So they appreciate the fact that it might take a longer period for parents to qualify. And they are thinking that once the child turns 18, maybe the child should also be entitled to their own citizenship at some point. But it's still subject to consultation, particularly in regards to children.
Okay, but on a neutral ground, without the law before, okay, it is the law. Like, how long does it take for a child to get how long does the child has to be in the UK before they can apply for the ILR?
On a skilled worker dependence.
Yes.
Currently, what is happening now?
Yes.
Yeah, currently, most children will qualify for indefinite leave to remain with their parents.
Okay. Yeah, thank you.
Yeah. If
Yes,
they are
ma'am.
dependents on their parents' visa, most children will qualify for indefinite leave to remain with their parents. But like I said, we're scratching the surface in this webinar. More the full details and everything. So it's again, do seek legal advice when you are putting in your application. We would highly recommend that.
Okay, ma'am.
Okay.
I get it. Yes, thank you, ma'am.
No problem. Any other question?
Okay, so please, I'm taking a consent because this webinar, we are going to post it on our social media all so that, okay, you ask the questions. So I'm taking a consent from everybody. I'm going to post it on all the social media so that other people can know that we are doing a great job and people can join the community. So thank you, ma. Thank you.
All right. Thank you everyone for joining us. We hope
Somebody
you've
have
enjoyed.
question.
Oh, good afternoon, everyone. Good afternoon. Thanks for the support. We really appreciate you as a community. Thank you very much, ma. And thank you for joining late because I'm at work here. Please, let me quickly ask the question, please. My question goes that if your sponsor, your license have been revoked, will they still be counting your ILR for you? That's my question, please.
Okay, so let me make sure I understand your question correctly. So if you are here on a skilled worker visa and they revoke your employer sponsor license,
yes,
the period, does that count as the indefinite leave to remain? Yeah, if the Home Office has not revoked your visa, you still have your skilled worker visa, and that period should still count.
You still count. Oh,
Yeah.
okay.
The revocation of the sponsor license of your employer does not mean your visa has been cancelled.
Oh, okay. That's what I want to know. Thank you very much, ma'am. Thank you,
No
Madam.
problem.
Thank
you everyone for joining us. We hope you've enjoyed the course and enjoy the rest of the day. Thank you. Have a